Welcome to Epstein Becker Green's webinar, Take Action Today. DOL provides important guidance regarding Persuader Rule. We are pleased to have Epstein Becker Green's Steve Swirsky and Adam Abram, co-leaders in Epstein Becker Green's Labor Management Relations team, co-presenting today's webinar to provide clarification on what employers should do before July 1st, 2016.
Good afternoon, and thank you everybody for being here with us today. We have a very full agenda and a very limited period of time and a topic that seems to have important new developments every day as we keep going. We are here to talk about the Persuader Rule, which was not something that was easy to get people interested in for 100 years, or since 1962, when the existing rule that has been replaced by the Department of Labor, was issued and has been applied and enforced fairly consistently over the last 50-plus years. What we've seen in the years of the Obama administration has been a number of different efforts by the government to essentially make it easier and more friendly for unions to organize, and to make it more difficult for employers to resist and to respond and exercise all of the statutory and legal rights that they have in communicating with their employees about why representation may not be the best thing. And the Persuader Rule has been a very important step in that process. In 2011, the Obama Department of Labor issued its first proposed amended rule. The amended rule that they proposed was to change something called, that's part of the Labor Management Reporting and Disclosure Act, which is where the Persuader Rule comes from. Everybody says, what is the LMRDA and why does it matter to me? The LMRDA is something that is a statute that was enacted by Congress in 1959. It grew out of what were referred to as the McClellan Committee Senate hearings that dealt with corruption and racketeering in the labor movement in the United States, and dealt with improper practices, unlawful payments, and a lot of things that employers and employees really were quite concerned about. The Senate passed this act, and it was signed by President Eisenhower, with the purpose of requiring certain reporting and disclosure by employers, by labor organizations, aka unions, and by organizations called by labor relations consultants. What is a labor relations consultant? Because that's one of the key things here in terms of who gives advice and what they can and can't do. A consultant, as you'll see on the slide, is anyone who works for compensation to advise an employer or a union or a labor organization concerning employee organizing, which is employee concerted activities or collective bargaining activities. This is a broad term. It includes law firms. It includes attorneys. We can go to the next slide. The LMRDA established a series of reporting obligations, so that if you take a business agent from a union out to lunch, or he takes you out to lunch, or you make a payment, that has to be reported. And it's to try and ensure that there are no improper payments, that things are open and above board, and again, as I said, to deal with some of the what was called racketeering. The reporting obligations include what are called persuader activities. Persuader activities can typically involve when an employer is engaged in attempting to communicate with its employees about collective bargaining, or most commonly in a union organizing campaign about why employees may be better off not being represented, and why the employer may want to encourage them to vote against representation. You can go to the next slide. The rules have always had an advice exception. It's Section 203C of the Labor Management Reporting and Disclosure Act. You'll hear a lot about that today, and it has been something that the courts have been actively considering, including in a decision that came down yesterday from the District Court in Minnesota, which we will discuss a little bit later in this program. Essentially, the way that the reporting obligations with respect to persuaders or consultants came down was that the Department of Labor, since 1962, has said that consultants who are engaged in persuader activity who do not speak directly to employees, who do not communicate directly with employees. So they don't go into the plant, they don't talk to employees in meetings or one-on-one about why they should not vote for a union or why they don't need a union. If it's not direct to the employees, that has been considered to be indirect. Indirect persuader activity from 1962 until now has not been subject to reporting. The Department of Labor, and you can go to the next slide too, has really made it simple for employers, made it simple for unions and lawyers by having this bright line test. The bright line test was, are you communicating directly? If you are, it's reportable. If you're not, it's not. That has been set on its head with the new rules that came in March. Go to the next slide, please. And I'm going to turn it to my partner, Adam Abrams in Los Angeles, to talk about what the new definitions are and the positions of the Department of Labor.
Thank you, Steve. And just to let everybody understand kind of where we're going, I think it's important that Steve kind of provided that background on where we've been. We're going to try to go through this as quickly as we can because we understand there's a lot of interest, and most of what we're going to talk about right now is background to I think what everybody or many participants already know. But for those of you that feel like we may be skipping through some things, we will provide a copy of all the slides so that you can review them and then ask us questions later at your leisure. Though, as Steve pointed out, we don't have a lot of time. July 1 is literally right around the corner. To understand what the Department of Labor is trying to do and how dramatic it is, I do want to focus on a little bit where the LMRDA came from and what the purpose of it was, which was really to address issues related to straw men, or what was referred to back then as stealth anti-union campaigns. In other words, employers paying people to kind of come into their workforce and not really disclose why they're there or who they are or what they're doing, with the purpose of directly talking to employees and convincing those employees to oppose a unionization effort or to start a decertification effort or to advance the employer's position in collective bargaining. And so it was a very narrowly focused purpose, really with the goal of protecting employees from what was viewed then as deceptive practices that employers were engaging in by hiring these labor relations consultants who would disingenuously present themselves as something else to employers. And as a result of, that narrow focus, the law also focused on what Steve described as the advice exemption and ensuring that employers were not being prohibited from engaging in what should have been legitimate activities. And Steve just referred to Section 203C of the LMRDA, which, just to give everybody a little bit of context, says that there's an exemption for any employer or other person from providing a report covering the services of such person for giving or agreeing to give advice to such employer. And it went beyond that. Then Section 204 of the Act provided what would be the protection from the attorney-client privilege that and it said, and quoting, "Nothing contained in this chapter shall be construed to require an attorney who is a member in good standing of the bar of any state to include in any report required to be filed pursuant to the provisions of this chapter any information which was lawfully communicated to such attorney by any of his clients in the course of a legitimate attorney-client relationship." And so what that resulted in is the long-standing old rule that Steve described to you, which provided a very bright line approach under what was known as the Donahue Memorandum, the Solicitor General, or the Solicitor of Labor, that described these requirements and said basically under the old rule that's existed for 50 years, 50 plus years, that it was not persuader activity or not reportable persuader activity if an attorney or a consultant did not provide that direct advice and the employer had the ability or did not provide that direct communication to employees, but rather gave the employer a suggestion of how to communicate to the employees, a draft of a speech or something to that effect, or a revision to a speech, but then provided the employer the ability to accept or reject or modify the advice that they were provided. And for the last 50 plus years, this has enabled everybody to have a very predictable, consistent, and workable approach. The response now, of course, is what is this new persuader activity and what is it done? And so if we look at the new definition, which was first proposed in 2011, and then sat relatively dormant for 5 years almost, we'll see that there's a dramatic new interpretation. The rule was ultimately amended on March 23rd, 2016, and by its statement applies to agreements entered into or after July 1 of this year. And what the requirement is, the major change that we're seeing is the now purposeful and very clear intent of the Department of Labor to focus on what it's considering indirect persuaders. And it now requires that there be a reporting obligation not only for direct persuader activity that has long been viewed as reportable, but also now for indirect persuader activity. And that results in a law firm or a consultant having to report and the employer also having to report the identity of the client or the labor relations consultant, as it may be, what the fee relationship was, and the nature and the scope of what was being consulted for. The DOL makes the very self-serving statement that the final rule does not affect attorney-client privilege, and it's taking the position that disclosing the financial aspects of these relationships does not, and the mere existence of the relationship does not interfere with the attorney-client privilege. I think many folks, if not all of us on this webinar today would take issue with that, and that's part of what is being litigated in the cases we'll talk about. So the new requirement for these indirect persuaders is that labor relations consultants, again, including attorneys, must report when they are engaged, not actually when they work, but when they enter into the engagement to plan or direct or coordinate managers who may persuade, or to provide them materials or revise materials or give recommendations on the types of materials that an employer may use to disseminate to their workers for persuasive purposes.
And one of the things I think that is, this is Steve here, one of the things that's so troublesome with these new rules and the new definitions is the fact that there is a lack of clarity in terms of what the Department of Labor is considering to be persuader activity versus what it is considering to be legal advice, so that if somebody contacts one of us and asks us to look at a script of a speech that they may be presenting to employees prior to a representation or election, or a communication piece that they may be sharing with employees during collective bargaining. And they ask us, is this lawful? Does this violate anybody's rights under any of our obligations under the National Labor Relations Act? Does it interfere with employees' rights? The DOL is taking the very narrow view that when an attorney answers those questions, that may be still subject to the advice exemption, but that if the answer to those questions then includes anything about how the message may be better crafted or may be better communicated to the employees and is not purely legal advice, that from the DOL's perspective, it appears that crosses the line and then becomes persuader activity.
And so, as the slide here points out, this isn't just the actual, what I think many people would commonly refer to as persuader activity, the drafting of a speech related to a union organizing campaign or a handout being given to employees, but it also includes union avoidance seminars or trainings that an employer may want to have its managers sit through. These are very common, and if the seminar deals with anything, as Steve just noted, that goes beyond this is the law, this is what you can and can't say, and ventures into, as most of these seminars or trainings do, this is how we would recommend approaching employees. These are good employment practices to keep employees happy, and ways to talk to your employees to ensure that they understand the benefits of remaining union-free. Those sorts of things would be included. It also goes into personnel policies or actions that would arguably be for the purpose of, and there's an intent aspect to the new regulation. If the intent of the activity is to persuade employees, then it's arguably covered by the text of the new rule. If the intent is to persuade an employee by drafting, let's say, an open door policy or an internal grievance policy the intent of which is to create employment policies that make the potential advantages of unionizing less desirable, that may be covered. And really the scope of this is yet known, and one of the interesting things is under the old rule and under the law itself, they focus on the language focuses on collective bargaining and union negotiations, whereas the new rule makes several references to the term protected concerted activities, which is much broader, as most of you likely know, and could get into things that such as advising on whether or not you should have a mandatory arbitration agreement or those sorts of things. So it gets really, really into some of the kind of common employee relations types advice that may become covered.
And if you look at that in the context of how the National Labor Relations Board has been acting for the last 6 or 7 years, what they have been doing is coming up with a much broader definition of concerted activity. They have been focusing a great deal on concerted activity, sometimes where it involves a single employee who's taking action that they deem to be having implications for the terms and conditions of all of the coworkers or some of the employees' coworkers. In tandem, the advice that an employer gets from counsel or from a consultant really in so many respects is likely to be, or conceivably it will be seen as advice and persuader activity by the Department of Labor, and therefore reportable under the new scheme that the DOL has said will take effect on July 1st, which is, as everybody knows, a very, very few days away from now. Not surprisingly, you can go to the next slide. The Department of Labor's release of these rules at the end of March has not gone unchallenged. There have been at least 3 lawsuits that are pending in the federal courts that are all significant challenges to this on a variety of grounds, including the position that the Department of Labor has essentially overstepped its authority and has created rules that are inconsistent with the terms of the actual statute, and that the acts that the Department of Labor is trying to impede essentially interfere with employers' First Amendment rights, the right of free speech, that the statute is overly vague and not clear and therefore is not enforceable. And there are procedural arguments that it doesn't comply with other federal regulations that assess the impact of a new federal law or a new federal rule from an economic perspective. The three cases that are referenced on the slide, and we have the materials concerning these cases attached in the on the PowerPoint that you'll get after the program, all are asking the court for injunctive relief, and in essence, to have the court prevent the Department of Labor from enforcing the new rule and the new definitions as of July 1st. And yesterday, in the case called LabNet versus Doing Business as Work Law Networks versus Hayes, and that's the case that's pending in Minnesota, there was a very interesting but unsatisfying decision from Judge Schiltz, who, while he did not grant an injunction and found that the plaintiffs in that case had not met some of the elements that they need to, specifically that they couldn't show that they would be irreparably harmed if the new definitions took effect, the judge found very clearly in studying the language of the rule and the statute itself that when the case goes forward, that the new rules are likely invalid because they require reporting of advice that is exempt from disclosure on under Section 203C of the statute. So clearly, what he has said is when he looks at these rules, he finds that they are inconsistent with the statute. They are violating the advice exception, but for reasons, he said, well, the employer who's involved hasn't shown that they will be irreparably harmed, hasn't shown that they will be subject to criminal or civil violations, and that he said that those are best sorted out in other, through proceedings if the Department of Labor challenges the employer for not filing the proper reports, or or its attorneys or advisors. We think that that's wrong. We think it's almost 100% certainty that will be appealed and to the circuit court. But there are two other cases where argument has taken place, also seeking injunctive relief. One in Arkansas, one in Texas, both in the federal courts, obviously, where it's anticipated that there will likely be rulings on the injunction petitions, sometime next week before July 1st. Briefly, Congress has attempted to rein in the Department of Labor. That has, they have passed their disagreement with this. Obviously, the President will not sign that. There is a question of what happens in the budget process, whether there may be a continuing resolution or other budgetary process that may result in a staying of these rules from going into effect, but I don't think anyone can say with certainty what's going to happen with that yet. So that leaves us here sitting a week before July 1st, before the effective date, saying, well, what do I do if I'm an employer? Is there anything I can do, or am I in this deep hole? And
yeah, and I think what we've seen is, and what many of you, I'm sure, are getting from maybe from us or from other counsel is advice on a very recent development that the DOL had in trying to clarify these rules and how they're going to enforce them, and recognizing some of the scrutiny that they're under. The DOL recently stated that the amended rule, that it won't apply to any agreement between an employer and a labor relations consultant, including law firms, including that it was entered into before July 1, 2016, in which the advisor agrees to provide, quote, persuader services on or after July 1, 2016, provided that those services would not have otherwise triggered the reporting obligations prior to the issuance of the new rule. In other words, in very kind of plain speak, if you have an agreement that asserts that you're going to retain a consultant, including a law firm, that to perform work that would not be reportable under the rules that have existed for the last 50 years, and that agreement is signed before next week, before July 1st, then you would have an argument, at least under the DOL's current interpretation of how they're going to enforce this, that would not be reportable activity. Obviously, if there was activity that would have been reportable under the old rule, then that would continue to be reportable. But the DOL is clarifying as of now, though not in the form of a formal rule or enforcement guideline, but in terms of communications that it's had, both with courts and with industry groups, noting that it's only going to apply the rule to, in essence, new engagements signed after July 1, on or after July 1, and old engagements or memorializations of relationships that occur prior to July 1 would not be impacted by this rule.
And this is confirmed in a status report that the Department of Labor filed in the District Court for the Eastern District of Arkansas in the Associated Building and Contractors case of Arkansas, where they say the rule is only applicable to arrangements and agreements made on or after July 1st and to payments made pursuant to arrangements and agreements entered into on or after July 1st, 2016. And that will be included with the materials in the PowerPoint afterwards through the links.
And speaking of those materials, you'll see that when you get this PowerPoint, there'll be a link that has many of the things that we've been referring to. We've been trying to get through this material as quickly as we can and give you guys really the 10,000 square foot, or I'm sorry, the 10,000 foot viewpoint. But both Steve and I and other folks at Epstein Becker Green are available for questions. We have a couple of minutes of questions now, if anybody is interested, that we can try to address. Otherwise, as many of these things we expect are going to be somewhat more particularized to an employer's current situation, you should feel free to reach out to either Steve or myself, and we would be happy to address whatever those issues may be.
If you write in the questions, we will get back to you as best as we're able to, as soon as we're able to.
So we are starting to see a couple of questions pop up.
So the first question we have is, how will they enforce this? Is it through an audit process, and what's the penalty for noncompliance? A great question. This, like so much else with this, it's a work in progress. The Department of Labor has been developing new forms that need to be required. What they've stated is when an engagement takes place, there needs to be a report filed by both the, quote, persuader and the employer. There are annual filings that need to be made. The Department of Labor, as far as I know, has not yet said whether they will be auditing or, whether they will be acting, to look at compliance and coming in and asking employers, have you had any persuaders this year? Where are your books and records that show that? One of the things that we anticipate, just from experience in other contexts, is there is likely going to be comment and complaint from labor organizations to the Department of Labor. One of the things that for those who deal with the NLRB and representation cases, have seen in the last few years is any time an attorney files a notice of appearance with the Labor Board and represents an employer in a representation case, the NLRB and the Department of Labor have automatically been generating questionnaires and notices to the employer saying, here are your obligations under, what were the Persuader rules until now. You have these obligations. I'm sure that those will be updated as of July 1 if the rules are not enjoined.
And that's a very good point that's made. I think one of the most important things that employers can do in this space is ensure that they understand whoever they're engaging on these issues, how they're going to respond. Because as Steve noted, in representation cases or even otherwise, the DOL may send something that implies that there's a reporting obligation, even if there may or may not be. And what you want to make sure is that you are on the same page as those that you're engaging. You want to ensure that there's not going to be a report made by a law firm that you're utilizing without your knowledge, and you certainly want to make sure that you're not reporting something that your law firm's not or that any other consultant is not, because that can create a larger problem as the DOL looks at this and says, well, gee, we're getting half of a report here. The consultant reported, but the employer did not. There's obviously an issue, and that could trigger some enforcement action that you'd rather not.
And in terms of what the penalties are, there are both civil and potentially criminal penalties with this. One of the points that Judge Schiltz made in his decision about why there was no risk of irreparable harm or it wasn't sufficient for an injunction was the fact that if an employer or a consultant is acting in good faith and they're not willfully violating the reporting rules, that they are not subject to the criminal penalties. I think that the guidance, and I've been struggling for what to call this information that's come out of the DOL in the last few weeks, because it's not a formal opinion letter, it's not a ruling. If an employer or a consultant takes action that is based on a good faith interpretation of that, I think there's a very strong argument to be made that certainly you're not acting willfully, you're acting in good faith, and you really want to be viewing as closely as you can to the fact that what you're doing, it was not reportable under the old rules, and that you're following the guidance of the advice exemption as it's existed.
And one of the other questions that I see on here that's fairly common is, well, why is this all happening and what is going on and where do these reports go? What is the intent? Well, the intent is obviously this is being pushed by organized labor. These are public reports. They get filed. They become accessible through the DOL's website. They're accessible by not only the labor organizations but anybody. They're publicly available. But labor organizations like to use this and point out either in union negotiations or during an organizing drive, your employer is, says they can't pay you any more money, but look at all of the money they're paying to their lawyers. That is their goal, is to be able to use those reports and to use them ironically, as a persuasive weapon against an employer's interest. In an organizing context or in even a negotiations context, to the extent that you end up with a labor negotiator who is engaged to provide that.
Employers X dollars to retain lawyers or consultants, as opposed to putting it on the table for wages. So one of the other questions of how does this impact in-house counsel and how does it impact HR departments? The answer is probably they are not going to be considered persuaders because they are employees of the employer, as opposed to going, if you go back to that definition, I think it was on the first or second slide of who a persuader is, But I have heard some people from DOL opine, you know, that they can conceive of circumstances where, you know, if a lawyer has a part-time engagement or a limited engagement by a company, and the DOL thinks that it's a form of subterfuge to get around these requirements, then I think that they would challenge that as well.
And one other question, you know, I mentioned negotiations, and people would wonder how that might be persuader activity given some of the other stuff. And those of you who engaged in negotiations have likely put out statements to the to your employees about the progress in negotiations or your positions in negotiations. And if you're using your employer or your counsel to aid in those, or to make sure that you're not direct dealing, but also to make sure that the statement is effective in terms of the bargaining objectives. Some may take the position that that would be reportable under the new rule. And for those of you that have engaged in negotiations and have seen, because you are a public company or whatever reason your executives' salaries are public, the use of that information during negotiations by the union as a wedge issue, you could anticipate this similar information being used for the same purposes. So I see we're about 5 minutes over. There's a few more questions. We'll try to get back to those individuals who phrased them directly, and if any of you, anybody else has a question or comes up with one, maybe after getting the materials, please feel free to reach out to us, and we will get back to you then. We appreciate all of your time in tuning into this and staying apprised of this very important issue.
Thank you for joining us today. This concludes our webinar, and in approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the recording and access to the PowerPoint materials. Thank you for joining, and have a great day.